Mr. Chief Justice Roberts, I had the good fortune to see at least a portion of your comments regarding the integrity of the court in a recent interview and believe there is an important consideration not yet been addressed. While I agree generally with your comments regarding the impressions of some and even many being closely tied to the outcome of matters before the court, not all feel that way. I, for example, am a member of a small group of acquaintances who rail against court rulings from both philosophical sides of the spectrum, as each is handed down. None of this small group had ever considered any improper behavior on the part of the court or its members. Sadly, that has changed over the past 6 years. It was my firm belief that no one person could ever damage the United States of America. That belief was founded on the impression that even the worst president would be checked by the Congress or the courts. I had, however, neglected to consider the machinations of the Congress, more specifically the Senate. One lone man refused to hold hearings required by the Constitution and so inexorably altered the face of the court. In fact, included in the court as currently constituted are two members who have not provided their perspective on when recusal of a justice might be appropriate. This, despite the remarks of the appointing official that no person would benefit from presidential appointment who would recuse for cause. Of course, neither was asked by a committee or Senate whose members are disproportionately attorneys. There is a third member demonstrably lacking in integrity and honor. As a scout and later United States Air Force airman, I was expected to protect others and ensure when necessary that their lives, rights, and property were protected, even to my own detriment. Mr. Gorsuch, by analogy, found a large sum of money on a restaurant floor and, knowing to whom it belonged and without attempting to return the thing of value, pocketed the funds. Members of the Senate Judiciary Committee are, presumably, almost all attorneys. Would there be an opportunity for your office to visit those allegedly highly educated people and remind them the burden of proof is on the party making the affirmative statement to be adjudicated? That being so, the nominator and appointee have the burden of proving fitness for office. Allegations of impropriety, if credible, cast that claim of fitness into doubt. I personally felt that Mr. Kavanaugh, more likely than not, committed an offense in his mid-late teen years. I found myself wondering, however, whether anyone would ever consider it just to punish a wrongdoer for life when the original offense carried no such sentence. I also wonder about restitution, remorse, and rehabilitation. I believe it is possible to accomplish these things, to earn the opportunity to again become a full member of society with no encumbrances because of bad past behavior. Mr. Kavanaugh, however, lost my support on his last hearing date when his emotions overcame him to the point of advancing conspiracy theories. Of note, Mr. Kavanaugh failed to state clearly and unequivocally that a recusal for cause would be forthcoming where there is an appearance of conflict. Ms. Barrett also failed to state clearly and unequivocally that a recusal for cause would be forthcoming where there is an appearance of conflict. This alone puts her votes in question when President Trump is a party to or has a special interest in the outcome of a matter before the court. Remediation for members of the court is a question for another time. Though I have a recommendation I would be proud to share with the court, should it believe that such recommendation might be helpful in the future. Until remediation of these three members of the court, I could only hope that, as Chief Justice, you will take the lead and seat only a quorum of justices in all matters. With respect, sir, I humbly submit. Thank you.